In Chapter 2, we're going to talk about the law of contracts. And contracts is one of those areas that hospitality managers touch literally every day of their working lives. Whether they are creating contracts to buy materials, whether they are talking with patrons that are coming into the restaurant or their hotel, just about everything we do as hospitality managers involves a contract. And most of us, despite the ubiquitous nature of contracts, will simply ignore them unless there is a problem, and sometimes even afterwards to our detriment. But because of the pervasive nature of contracts in hospitality management, I think it's important you have a solid foundational understanding of the basic rules and laws surrounding contracts. So to that end, today we're going to identify the elements necessary to form a contract. We're going to talk about some of those elements, including offer, acceptance, and consideration. We're going to explain the difference between an express and an implied contract. We're going to distinguish between bilateral and unilateral contracts. We're going to look at void, voidable, and unenforceable contracts, and then we're going to talk a little bit about statutes of limitations with regards to contracts. So the terms contract and agreement are interchangeable, right? So agreement connotes that there are two people that understand what's going on. And a contract is basically an agreement between two or more parties for value that is legally enforceable. And unless all of the elements of a contract are present, the contract is not legally enforceable. In a law office, a lot of times when clients bring us contracts, they're worried about the consequences of breaking a contract. But where we start, and where you should start, your understanding is whether or not a contract is even present. And in order for a contract to be present, there must be all of the elements present, offer, acceptance, and consideration being three of those. Otherwise, it's not legally enforceable and you don't have to worry about the consequences. So depending on how deeply you study contracts, there's between 5 and 7 elements. Some of these can be broken down into separate elements necessary for a contract to even be present. Before you worry about the consequences of breaking a contract, you have to see whether these elements are present. And you have to go through these step by step by step. If any one of these is missing, you don't have a contract, and therefore there is nothing to enforce. So before we talk about the necessary elements of a contract and whether or not something is present, I want to make sure you understand the difference between customer service and the legal enforceability of a contract. A lot of times in customer service, we're going to bend over backwards to make sure our customer is happy. So regardless of whether or not these elements are present, whether or not we have an enforceable contract, we're going to do what is right for the customer. Where this becomes more important is when you're dealing with suppliers and contractors and things like that, and they're trying to enforce something that isn't present. So always keep that in mind. While we're learning the elements of a contract and whether it's present and enforceable, there is a difference between taking care of a customer as a hospitality manager and dealing with contract law. So we're going to talk about each one of these elements in a little bit more depth, and we're going to start with an offer. An offer is a communication by one party, who's usually called the offeror, to another party, who's usually called the offeree, of the offeror's intent to be bound by a contract. It's a proposal to exchange promises, or exchange promise for acts, or exchange something that is available for the offeree to accept. And it can't be too vague. It can't be a proposal. It can't be a solicitation for proposals. It can't be an invitation. It can't be a sarcastic joke. It can't be an advertisement. That may be the most important one for hospitality managers. Is advertisements are normally not invitations for acceptance. They're not offers. So the offeror has to have the requisite intent to be bound. And how do you determine someone's intent? It's very difficult. So the law is going to look at whether or not the offeree, the person to whom the offer is made, can be identified, whether or not there is a price present, whether the subject matter of the contract can be easily identified, whether there's a reasonable time frame for performance. So you can see how an advertisement may not have all those things because it's going out to the general public, and the subject matter may be identified, but the price may not be set. The time frame is not there. It's too vague to be an offer. So if you put out an advertisement for a hotel room and someone comes in and says, hey, I want to accept your offer for the hotel room, that is not necessarily enforceable. Now, if you have the hotel room, obviously you want to rent it, but if you don't have one, it's not a contract that can be enforced. The second element in a contract is acceptance. An offer must be accepted in order to create a contract. So if I offer to sell you my Ford pickup truck for $8,000, and you say to me, I'll take it, you have accepted that. That's a verbal acceptance, right? If you hand me $8,000, you have also accepted that offer. That is accepting it by performance. If you stand there with your arms folded, don't say anything and don't do anything, you haven't accepted the offer. In general, there's no acceptance by silence or inaction. Under common law, it's also important that the acceptance be a mirror image of the offer. So for instance, in that same scenario, if I offer to sell you my pickup truck for $8,000 and you say, I'll give you $7,000, well then my offer of $8,000 has been terminated and you've made a counteroffer. Now the offeror and the offeree have switched places. While I was initially the offeror, saying I'll sell for $8,000, because you have rejected my offer and offered $8,000, you've become the offeror, and it's up to me whether or not I accept that deal. We're also going to talk about some differences in acceptance with regards to unilateral and bilateral contracts in just a minute. But normally in practical application, if we are writing a contract, we want to make sure that we are clear about the terms of acceptance in the contract. In other words, how is this contract considered accepted? Next element we'll talk about is consideration. Consideration is a benefit to the promisor or a detriment to the promisee. It's something of value, and the value is defined by the parties, not by the courts or anybody else. So it can be money, which we all agree has a certain value. It can be property, or it can be a promise to do or not to do something. Now, the reason it's important to have consideration is consideration is the difference between something being a gift and something being a contract. Here's what I mean. If I say I offer to give you my pickup truck and you take my pickup truck, that's a gift, right? Because there's no consideration on your part. There's consideration on my part. I'm giving up something of value, but you are just merely taking something without promising anything in return. If in the original scenario I offered to sell you my pickup for $8,000 and you offer to pay me out $8,000, now consideration has changed hands, right? There's both a benefit and a detriment to me. There's a detriment in that I'm giving up my pickup, but a benefit in that I'm getting $8,000. And the same thing on your side. There's a benefit and a detriment. You're giving up $8,000, but you're getting a pickup worth that much money. So consideration is what makes something a binding contract at this point instead of a gift. A gift is a voluntary transfer of property by one person to another without any consideration or compensation. So let's talk just briefly about these last two elements. Capacity comes in two forms, either legal capacity or mental capacity. Legal capacity is pretty simple. In most states, if someone is under the age of 18, they do not have the legal capacity to enter into a binding contract. If they are over 18, they do have that legal capacity. Mental capacity is usually something determined by the courts. A court has to actually say that someone is non-compos mentis or doesn't have the mental capacity in order to enter into a contract. If the court hasn't done that, then it's a very long hill to get up in order to prove that someone doesn't have the requisite capacity. So in other words, if a 17-year-old walks in and offers to buy a pickup from a car dealership, and that car dealership sells them the pickup, the 17-year-old can bring the pickup back at any time and say, hey, I want my money back, because the contract is unenforceable. If that person is over 18, then they obviously have a valid and enforceable contract. The same thing goes for mental capacity. If someone who has been declared incompetent goes in to buy a pickup and it's sold, they could bring that pickup back and get their money back as well. The final element is legality. It just has to do with the purpose of the contract. So the classic example there is murder for hire. If two people get together and one offers to pay another to kill somebody, and the person who is paid to do it doesn't do it, that's not something that the courts are going to enforce, because the subject matter of the contract was illegal. So the subject matter has to be legal in order for the contract to be enforceable. So when you put all those things together, you go through step by step by step, all of those elements have to be present in order for us to have an enforceable contract, and before we start worrying about the consequences of not performing on that contract. So that gets us through our first two competencies in the basic foundation of contracts. Let's talk about the difference between express and implied contract. An express contract is a contract that is set forth in words. They can be oral or they can be written. But express means that each party knows the terms and conditions, and it's prudent to record oral agreements in writing, but it is not absolutely necessary in order to have a contract. You've all heard the term verbal contract. Verbal express contract is something that can and is enforceable in many facts. Implied contracts is implied by the acts or conduct of the parties, and we can talk about implied in fact or implied in law. Let's talk about, though, first of all, an express oral contract. Many of you may remember Wimpy, the Popeye character, that would say, "I'll gladly pay you Tuesday for a hamburger today." That is an offer that has been accepted because he's got the hamburger, and it is an oral express contract. Both of the parties know the terms. Payment is going to be made on Tuesday for the hamburger that is provided today. The subject matter is the hamburger, and we know probably from the menu what the price is. So that's something the offer, acceptance, consideration, legality, and capacity are all present, and we have an express oral contract. From a hospitality management standpoint, probably the most prevalent example of an an implied contract, one that is inferred by the acts and conduct of the parties, is in a restaurant, just like with Wimpy. But what do we do when we go into a restaurant? We sit down, we order from the menu, we eat the food, and then we know at the end what has to happen. We have to pay for it. No one is saying, I offer you this, I accept this. We're not talking about the consideration. Everything there is implied, and we know at the end of that meal we're going to have to pay. Right? There is an implied contract inferred by the acts and conduct of the party. I order from the menu, the food is brought out, I eat the food, the bill is brought. The acts and conduct indicate that I have to pay, so the contract has been implied and is, of course, enforceable. So again, express can be oral or written. It's one where each party knows the terms and conditions up front. Implied is usually created by the acts of the parties, and it's inferred from the facts surrounding the transaction and the parties' behavior. So that brings us to competency number 4, distinguishing between bilateral and unilateral contracts. So bilateral contract is one where each party promises performance to the other. It's probably the most common type of contract and the most easily recognizable as a contract. If we sit down at a table and we negotiate the sale of my pickup truck again, and I say, I offer to sell you my pickup truck for $8,000, and you say, I promise to pay you $8,000 for you selling me your pickup, we have a bilateral contract, a promise for a promise. Even though I haven't turned the keys over yet, and you haven't taken possession or given me the money, we have developed a bilateral contract, a promise to do something in exchange for a promise to do something. Bilateral contracts are almost immediately binding once the two promises are made, as long as all the other elements are present. If you contrast that with a unilateral contract, that's one where we have a promise in exchange for an action, a promise in exchange for performance. The offer is accepted when the performance starts. You can contrast that two-sided contract with a unilateral, which is a one-sided contract in which only one party is making a promise and the other party is acting or refraining from acting. And the contract does not form until that second party either performs the act or begins to refrain from doing some act. So the distinguishing factor between these two contracts is, when is the contract formed? In a bilateral contract, the contract is formed, it is enforceable immediately when the promises are exchanged. In a unilateral contract, the contract is not formed and therefore enforceable until the second party acts or refrains from acting. So the act of performance, or refraining in this case, is the acceptance and creates the formation of the contract. So that brings us to our 5th competency, defining void, voidable, and unenforceable contracts. The first term there is void, and again, we'll go back to our example of murder for hire. Some contracts are void on their face, and they have no legal effect whatsoever. So if the contract is for something that is illegal, it is void on its face, just as if it never happened. A voidable contract is one that can be affirmed or disaffirmed. So it is potentially enforceable and can become enforceable unless it is voided by one party or the other. And usually the terms of the contract are going to dictate how that contract is voided by one or the other. But it can also be, going back to legality, it can be something dealing with a minor. So if a 17-year-old, in our example, goes in and buys a pickup truck and is making payments on that pickup truck, they are performing under the contract. Up until the time they turn 18, that contract is voidable. As we said, the 17-year-old can go in and give the pickup back and get their money back. Once, however, they turn 18, that contract can be affirmed. So if they're making payments while they're 17, they continue after they turn 18, and maybe they're 19 at this point. Just because they made the contract when they were 17 doesn't mean that it is now, when they are 19 years old, voidable. That contract has been affirmed, it has been ratified, and it can no longer be void. So a contract that is void on its face, or a contract that is voidable and has been disaffirmed, is a contract that is now unenforceable. So if we go back and we look at our competencies here, we now know the definition of void, voidable, and unenforceable. And that leaves us with competency number 6, statutes of limitations. So defining statutes, remember from our discussion in chapter 1, where we said legislatures, the lawmaking body in each state or federally, make laws. Those laws are called statutes. So a statute of limitation is something that fixes the time in which particular lawsuits must be imitated. It limits the amount of time one person has to bring a lawsuit against another person. So for instance, the statute of limitations for enforcing a contract may be 10 years. If the person that wants to bring suit about a contract doesn't bring it within 10 years from a date certain, they are barred from ever bringing that. And those statutes of limitations differ from state to state. The reason we have these is we want to protect people from being worried about getting sued for the rest of their lives for doing something. So eventually the threat of a lawsuit is going to fall off for people who have died. Evidence gets lost, people forget the terms of contracts, eyewitnesses are gone, and claims are forgotten. So the legislatures have come up with these statute of limitations so that we don't have to worry about being sued forever and ever and ever. So that is a very, very brief overview of the law of contracts. There's more information in your book. Again, it's an area that is ubiquitous in our everyday lives as hospitality managers, and something that you should be familiar with if you're going to be in this profession. As always, if you have any questions, don't hesitate to reach out to me, and I hope you have a great day.